Welcome to the latest episode of Mayor Brown's Quick Insights on Congressional Investigations with Michael Levy and Andrew Olmem, our weekly 5-minute perspectives for in-house counsel and government affairs executives on the most interesting and challenging issues surrounding congressional investigations. I'm Michael Levy, a white-collar defense partner at Mayor Brown. My partner, Andrew Olmem, is a former Republican chief counsel of the Senate Banking Committee. The courts have been very active deciding cases arising from congressional investigations lately. We've already discussed in prior episodes the Supreme Court's decision in Trump's v. Mazars and the D.C. Circuit's multiple decisions in the Judiciary Committee v. McGahn cases. The D.C. Circuit decided another interesting case on congressional investigations at the very end of 2020, Maloney v. Murphy, which involved a request to the GSA that came from minority members of the House Oversight and Reform Committee. Andrew, can you bring us up to speed on the Maloney v. Murphy decision and what you think it means for congressional investigations going forward?
Sure, Michael. The question presented in the case was whether the 8 members of the House Oversight Committee had standing to bring suit against the General Services Administration to comply with an information request the members had made under Section 2954 of Title V of the U.S. Code. Now, Section 2954 is not a well-known statute. It dates back to 1928, and it requires any executive agency to provide any information requested by any 7 members of the House Oversight Committee or any 5 members of the Senate Homeland Security and Government Affairs Committee. As we've discussed in prior episodes, normally information requests are issued by committee chairs or by a majority of the committee. In this case, however, 8 members of the House Oversight Committee, not a majority, requested the information from the GSA. Now, the GSA declined to provide the information, so the members filed suit seeking to compel this GSA to turn over the requested information. The district court dismissed the case for lack of standing. However, the D.C. Circuit, in a 2-to-1 decision, reversed the district court and ruled that the members of Congress do have standing to seek information from GSA under Section 2954. For the sake of time, I'm not going to go through the full reasoning of the court on whether and when Congress has standing to bring suit in federal court. Instead, let me answer your question on the practical results of this decision if it withstands subsequent review. Most importantly, the decision potentially allows members of the minority party in both the House and Senate to conduct their own investigations of the executive branch. Given the results of the most recent election, this means that congressional Republicans could have a tool to conduct oversight of the administration. It's worth noting, however, that the Maloney case was actually brought by Democratic members of the House Oversight Committee when Republicans held the majority in the House. This shows how judicial decisions governing congressional investigations can cut both ways politically. Second, although Section 2954 does not authorize information requests of private parties, congressional investigations of the executive branch often implicate private parties. Government agencies have lots of information and documents related to private parties, private companies, and individuals that could potentially be obtained through Section 2954. As a result, the decision creates another means by which private parties can find themselves involved in a congressional investigation. A third consequence of the decision is that it could weaken the authority of the chairs of the House and Senate Oversight Committee. Members of the oversight committees, regardless of party, don't necessarily have to go through the committee chair to request information of the executive branch. In the past, there have been cases where a committee chair has diverged on policy from the other members of the committee, including members of his or her own party. If such a situation occurs at the oversight committees in the future, Section 2954 could give the rank and file members of the committee a means to go around the chair. While the decision in the Maloney case could certainly have some of these significant consequences, it's going to be worthwhile to watch and see if the decision stands. The D.C. Circuit Court judge who dissented in the case was Douglas Ginsburg, the prominent conservative jurist. In his dissent, he stated that he did not believe that the members of the Congress had standing to sue under Section 2954. Michael, as a former Supreme Court clerk, do you think that his dissent indicates how the Supreme Court could rule on the case?
Thanks for putting me on the spot, Andrew. I'm smart enough to know that trying to predict what the Supreme Court's going to do is truly a fool's errand, and it is in this case as well, particularly because I'm not sure the case is actually going to get to the court at all. Given the new administration, it may well be that the GSA simply provides the information and moots the case out. Whether or not that's going to continue to prevent the issue from getting to the Supreme Court is a different issue, as now, as you said, the Republicans could use this authority to go seek administration information from the Biden administration. So certainly the question of the roles and the respective powers of Congress and the executive to engage with each other, and particularly Congress's ability to exercise its oversight over the administration, are ripe issues that have been hotly debated, and I think they'll continue to be so. So with that, thanks for joining us for this episode of Quick Insights on Congressional Investigations. We hope to see you next week. And if you want to watch any of our earlier episodes, you can find all of them at mayorbrown.com/congressional investigations videos. Thanks.